Good afternoon, everyone. My name is Michael Fernandez. I'm a partner of Real Mestre and an adjunct professor of law at Fordham University School of Law in New York City. Delighted to be here with all of you for the second event that NYLON is putting on. NYLON is an organization co-founded along with Federico Singaraja, Thais, and Kabir Degal that tries to bridge the gap between two very important markets in the international arbitration world, London and New York, two nations separated by a common language, as quoted by Bernard Shaw. So we are delighted to have this event that brings together practitioners with experience in both jurisdictions to talk about their experiences. And I will turn it over to Flavia, who can talk about as well some of the co-sponsoring organizations supporting this event.
Hello, my name is Flavia Mensch. I'm a practitioner based in Brazil, now acting mostly as an independent arbitrator. And I am one of the co-chairs of the Rising Arbitrators Initiative, called by us by RAI. RAI was launched in October 2020, and it seeks to support young arbitration practitioners, usually under 45, who have already have their first appointment, by promoting a network for these rising arbitrators so that they can exchange their views and career in that field. And we are really delighted to support this event promoted by the New York London Arbitration Association, especially because of the topic of today's event. I welcome you all, and I hope we have very fruitful discussions.
Hi, everyone. My name's Fred Singaraja. I am a barrister and one of the members of NYLON Arbitration. I'm also, although I've just learnt I'm technically perhaps too old to be a member of RAI, I am a member of RAI. I may have just slipped through the net. So it brings me great pleasure to be able to bring this event to you. We have three incredible guests with us today. So I'm going to get them to just say a couple of words about themselves, because I don't think I could do them justice. So let's start, first of all, with Dana. Dana, if you could just introduce yourself.
Yes, hello, everyone. My name is Dana MacGrath. I am currently a full-time arbitrator based in New York City. I previously was an arbitration practitioner with several big law firms, and I also was in the arbitration funding space for a few years. And it's a pleasure to join you today. I look forward to our discussion.
Thank you very much, Dana. And now maybe Alex.
Alex Wilbraham. I'm an independent arbitrator. For 19 years, I was in the International Arbitration Group at Freshfields, Brookhouse Derringer, first in Paris and then in Washington, D.C. I'm still based in Washington, D.C. and recently, after going full-time as an independent arbitrator, I became a member of Arbitra International, which is a group of all of whose members are independent arbitrators based in London and Washington and Dubai.
Thank you very much, Alex. And last but by no means least, Jay, if you could introduce yourself.
Thanks, Federico. Good morning, good afternoon to everybody. I'm Jay Alexander. I retired from Big Law about 18 months ago, where I had been sort of one of the founders of the Baker Botts International Arbitration Group many years ago now. I started my independent practice when I retired as an arbitrator, and it is a blast. So I look forward to talking to you all today.
Great. Thanks a lot, Jay. I'll now hand over to Flavia, who'll kick off our discussion today. Thank you.
Thank you, Federico. First, I would like to just correct myself and say, we do not kick anybody out of RAI. So probably when you applied, you were under 45, and we definitely want to keep everybody who's interested in continue to discuss among rising arbitrators, because I think we're always here to learn more. So we do welcome some arbitration practitioners over 45. So I think we already started to talking about what you wanted, but I think as a first question, I would like to address a little bit about you and your practice, if you could share with us how you got into arbitration early on and how was your move from counsel to full-time arbitrator, that would be great. Maybe Dana can start as ladies first, but feel free, anyone, to just step in.
I'm happy to start. Thank you. So my story is probably similar to many, that I started as a litigator, so to speak, in disputes in a big law firm. I started at Sullivan and Cromwell. I was then at O'Melveny, Allen and Overy, and Sidley before I left big law to go independent as an arbitrator. And in my early days as counsel, as a practitioner, I got involved in arbitration sort of fortuitously because a big case came in and there was a need for an associate who, among other things, could navigate legal materials in French. And I was eager to learn about arbitration. And so I did a deep dive into arbitration through that case and became quickly a part of the arbitration practice group, and have since specialized in international arbitration. That case that was my sort of entry to the arbitration world had a post-award life of award enforcement. So I also had the opportunity to learn a lot about award enforcement, both in the US and in several countries, and that may tie into a question later. I guess I should segue, so after practicing in big law, I was in arbitration funding, worked with a third-party funder, Omni Bridgeway, where I learned all about arbitration funding. And then after Omni Bridgeway, I transitioned to being a full-time arbitrator. And while I was a practitioner in big law, and then while I was in arbitration funding, I was at the same time taking a few arbitral appointments as arbitrator. It wasn't, the main part of my practice, but I did make an effort early in my career to try to develop the skills as arbitrator, so that when ultimately I became a full-time arbitrator, I had experience.
Thank you.
Jay, you want to jump in?
So I go next? Sure. Yeah, why don't I jump in? Like Dana, I did not start international arbitration at all. In fact, I didn't know what international arbitration was for the first 15 years of my practice. I was in a small white-collar criminal defense firm and did a lot of trial work and criminal investigation work. And that firm merged into Baker Botts in 2001. And when that happened, they had a NAFTA case, and they needed somebody to lead the hearings for it. And I thought to myself, well, how hard can that be? Turns out it was pretty hard. The late Professor Crawford was the chair of the tribunal, and I had some associates who knew something about international law, which was fortunate for me. So I read a lot of ICJ cases and put together the brief and went to the hearing at the World Bank. And I will never forget, during that hearing, I was arguing, and I had an ICJ case that was right on point for this jurisdictional question. And I leaned over and I was talking about that case, and Professor Crawford leans back over and he says, "Well, Mr. Alexander, the case does say that, but we all know it doesn't mean it." And that was when I knew I was going to love international arbitration. And really, frankly, from that point on, we did win that case, and we then set up an international arbitration practice at Baker Botts, and the rest was history for me. It's been a blast. I've really loved the career.
Thank you, Alex. Do you want to
share? So that's how I got into it.
Thanks.
Certainly. So my route into arbitration was I was working at a firm in London where I trained called Lawrence Graham, and we did a lot of shipping and insurance cases, and I found that a lot of them were arbitrations. And so I found myself doing increasingly more arbitration. And as I moved from there to other firms, I found that a lot of the work involving Latin America, which interested me because of my languages, were all arbitrations. So bit by bit, I became drawn into it until eventually I joined Freshfields in Paris in 2005, I think it was. And I've never looked back since then. Like a lot of people, it was a sort of a stumbling forwards process to begin with. I didn't expect that's where I was going. I never imagined that's what I would do, but that's where I ended up. And then after Paris, I eventually ended up in the States because it was Washington was near the World Bank, and we had a lot of cases there.
Thank you, Alex. I think all of us share like the very first case. It's something that brings us like, well, that's what I want to do. I think we are very privileged to work in, at least for me, it's such a challenging and interesting profession that he always wants to have like other cases, and that is like very, really a pleasure for us. So maybe we can move to the second question. Federico, I'll get back to you.
Thanks, Flavia. Yeah, well, just listening to you guys, you know, it seems to me like the first free rock of crack for international arbitration was on something to do with the international nature. You know, Dana talked about the French case and accidentally stepping into it. Alex, I know you, so I know that you're married to a Brazilian. You have those connections with Latin America, etc. You're an Englishman in not New York, unfortunately, in Washington, but you know, we'll come back to that. And Jay, with your NAFTA connection there. So, you know, one of the questions I get asked a lot is, if you're a barrister, you know, does every barrister want to take SILF? Does every barrister want to be a KC? And I wonder whether every arbitration practitioner ultimately wants to be an arbitrator. So let me put that question to you. First of all, you know, what did you do to get your first appointment? How did that come about? And is there something memorable in appointments that you've got? One of the things I always say is I can trace back every appointment pretty much to some kind of BD connection. But let me put that to you guys. So let's start with Alex. Let's start with you.
Well, I suppose my route into becoming an arbitrator was, I was just contacted by the ICC and asked if I would be a sole arbitrator in a small case involving, I think it was because I was based in the US, but I was not a US citizen at that time. I am now, but I wasn't then. And it was a small dispute. And I found myself chairing a procedural discussion between two different parties and their counsel. And I think a lot of arbitrators I've spoken to have this experience, is that when you start, having probably gotten used to doing large cases that are run by two law firms on either side who are familiar with the way things work, when your first arbitration appointment, you get your first arbitration appointment, very often you find you have two law firms who are not used to arbitration at all. It just happened to be in the contract, and they accidentally find themselves in sort of muddling through. And it's quite difficult because you find them arguing about procedural issues that really you're not used to in well-run international arbitrations. And it's quite a job to actually untangle the confusion of the parties when you're in these small cases, and to get a procedure that's going to work efficiently and well. So I remember my fear at the beginning of just like, how am I going to sort this out? Eventually, it does get better though, with time.
I think that's the joy of it, actually. You know, having practiced in these sort of very traditional international arbitrations where there is the way. I'll never forget one time a barrister once said in a procedural conference, well, of course we're going to do it the English way. To which I responded, well, I don't know what the English way is. I know what the arbitration way is. But in when you get firms that are not so integrated in the international arbitration community, it really causes you to think about, okay, what is it about international arbitration that makes it so special and unique and distinct from judicial proceedings, and allows you to tailor the process to the nature of that dispute. And it's kind of freeing, I find. I really like it.
Yeah, Jay. So international arbitration is like, for those who are Star Wars fans, like the Mandalore way. This is the way, right?
Yeah, exactly.
If those follow Star Wars, then you'll have to look that reference up. But turning to you, Dana, what other pearls can you add to that?
So I got my first cases also from arbitral institutions that reached out, and then I got a few, based on my, my work as arbitrator, sort of then additional appointments came in. Many of the arbitrations that I was appointed to, either by an institution or by a party, are seated in the US, but I've been involved in many arbitrations that are seated in London as well. It's been interesting, especially when I left big law and was in arbitration funding. I saw a number of different kinds of arbitrations than I would have seen at Sidley as a partner there. So I totally relate to the experience of others where you are either a sole arbitrator or chairing or acting as an arbitrator in a case where counsel are not necessarily of the same background as you have or don't share the same background. So you really have to educate gently the counsel team as well as run the case efficiently and fairly. So having seen a total smattering of cases in the funding industry for a few years, I felt that when I went full-time as arbitrator, I'd sort of seen it all, but I'm still seeing it all. Like I'm still getting cases where new issues come up. And I think that's really part of the joy of being an arbitrator is every case has some new issues, and it's an evolving area, and I really love it.
Thanks, guys. It sounds to me like the...
May I add something? Well,
yeah.
Just two quick comments. First, I actually wonder, how do you trace your arbitrator appointments? Because I think my first I can trace, but most of my appointments, sometimes I don't have a clue how they decided to choose me, including the case we worked together recently. But my first arbitration appointment, I think, since I'm a bit younger, I had the privilege to work as arbitral secretary before. So my first case was actually as chair, appointed by two really senior arbitrators who I had worked before as arbitral secretary. So I didn't got like this very first case. Both counsels were well educated. So my first case was not that small, and I was already a chair, but with really support of my two co-arbitrators. Was a great experience. But later on, I did get appointments from arbitral institutions with cases with non-educated parties that I had faced the same issues as you did. But I just wanted to share and add that.
Thanks, Flavia. That's really helpful. I can trace my I think pretty much every appointment. In fact, unlike you guys, my first appointment came from party appointments, and I had been a member of one of these, organizations, whether it be ICA or IBA or whatever it is. And I'd worked on committee with somebody for years, decades. I never had any work from anyone in that committee until 10 years later when I'd forgotten all about it. Lo and behold, I got an appointment from somebody who I'd met through the committee. So I can only presume this there was only a couple of people who worked in that area in that firm, which is a large international firm, but I'm pretty sure that came from the partner, and I later discovered that that was correct. And the only appointment I didn't know where it came from was an institutional appointment. It was the LCIA. And as you guys probably know, I don't really operate in London that much, actually. Most of my work is outside of London. So I didn't even know that the LCIA knew who I was. And when I got my first appointment from the institution, I was very taken aback. But then it transpired that I had met the caseworker who put my name forward in a university alumni gathering, social gathering, and then that transpired that way. So I managed to trace that one as well. But going back to that point, because from you guys, it seems that your appointment, or at least your first taste of sitting, came from an institutional appointment. Not you. So tell us about yours, Jay.
No. Yeah, so mine, actually, the first handful of mine all came from firms of arbitrators who had seen me appear before them as counsel. And so I think, and based on some discussions, I think I know that based on their experience of me as lead counsel in cases, they felt comfortable or recommended me to their partners to serve as a party appointed arbitrator in their cases. And so, the first 1, 2, 3, 4 were all like that, some quite large, and that was good for me because it gave me a chance to sit on a tribunal without being chair before I got thrown into the chair role, which has actually been quite a blast as well.
Great. So let me ask this then, because a lot of people, I think, who are looking for their first appointment, seeing as we're doing this with Rye, I've had a lot of discussion about courting the caseworkers, the institutions, going to their events, etc. But it seems to me that they can only appoint you maybe once a year, if that, because they've got to appoint lots of people. Jay, you've just said that you got your appointments by appearing before arbitrators who then liked what they saw, as it were, and then consequently appointed you. So, Alex, let me ask you first. What do you think is the best way forward? A, to get in, maybe your first one, but then B, to actually have a career?
Yes, I think I echo what Jay said, although my first appointments came from institutions, and I think subsequently, I think it's the national committees that appoint them in consultation with the secretariat of the ICC. I'm more familiar with how that system works, and it varies from institution to institution. But subsequent appointments, and more recently, I found come from, exactly as with Jay, opposing counsel very often who have seen me working on cases. I think it shows you that it's very important to work with opposing counsel in a collegiate way and as cooperative a way as you can, given the contentious nature of what we do, because that's one of the things I like about arbitration, is that everybody does tend to, after a while, come to know each other. That there are certain rules, just as and certain conventions that are unwritten, if you like, about how you negotiate, say, about procedural issues. And I think it creates a more friendly and user-friendly environment because you have to cooperate to a degree with opposing counsel. And if you're viewed as being rational and reasonable on that basis, that is arguably why they think you'd be a good appointment at the end of the day, because you can show that you're rational even while disagreeing. And so I think it's a very good way to start off. Moving forwards, I think it is important at some stage to let people know that you're independent, because often while I was working in big law, I had to turn down an awful lot of appointments or invitations, or at least let my name go forwards, because of conflicts. And I think once you know that you're letting that go, and that you've no longer got anything like as many conflicts because you're out of being the counsel game, or mostly out of it, that's a very helpful thing, because it means parties know, and the law firms are going to be they're not going to waste 3 days while you go through the complex conflict checking process that law firms have, and then they've got to spend another 3 days going to someone else, and it can take 2 weeks sometimes to just clear conflicts with a potential arbitrator. So I think that's a key point, is to reach the point where you declare yourself to be independent.
Thanks, Alex. That's really helpful. Dana, before I turn back to Flavia, I wanted to turn this on its head, because everyone's saying, what I got from that is, be a good lawyer, be a nice lawyer, make a good impression, work hard, and you'll sooner or later you'll impress someone, and it may come knocking. Opportunity may come knocking at your door. But let me ask you a provocative question, Dana. So, would you appoint, either as chair or when you were counsel, as an arbitrator, someone who you thought was a real pain but was obviously brilliant? Let me ask that. Can you just be a sheerly great lawyer, but somewhere with proper social, a lack of social skills? Let's put it that way. What are your thoughts on that?
It depends which side you're on.
Yeah, you're asking Jay, right?
I'm asking you, Jay, now. I'm asking you.
You're asking me?
I'm asking you. Any thoughts on that?
So, I think that one of the benefits of arbitration is that the members of the tribunal are typically pretty seasoned and collegial and make an effort to get along. That said, I have seen both as counsel and as arbitrator, some arbitrators who have very strong personalities, and that doesn't necessarily mean that they are unable to get along with people. They have strong views and a strong presence, but if they have the background and the skill set that is appropriate for the case, I think that they're an asset to the tribunal. But it's nice to work with people who are pleasant and collegial. And it's also interesting to work with people who have some stronger personalities that you wouldn't necessarily think would be, the best dinner companions. Actually, they become, really, once you get to know them, most people in this field are pretty genuinely nice, even with strong personalities.
Great. Thanks, Dana. That's really illuminating as well. And okay, so obviously your hard legal skills, I'm getting from that, is what's really going to shine. But it also helps not to be a nasty person as well. Too far on the spectrum and having social skills. Right. On that note, before I dig myself a hole, I will hand it to Flavia.
Thanks, Federico. I think actually Alex already started digging into our next topic. And basically, I know the three of you moved recently to being a full-time arbitrator. And then a lot of people do question me, at least, or we always write, people ask, when should I do this move? When I should leave the big law firm and be a full-time or an independent arbitrator? Do you have any advice? And also, how do you prepare for that? Because it's very different to be by yourself, even in terms of deal with a conflict check and financial aspects. At least you don't have the whole infrastructure of a big law, but you still need to do high-level work. So how do you deal with putting up together your own structure? And also any advice for people who are in this time deciding whether they should take the step and get out of the big law firm, put themselves in the market as a full-time arbitrator or not? I know it depends on jurisdictions, but your views, maybe done now, or maybe Alex that already started speaking, any of you can start.
I'm happy to share some thoughts and discuss with you all. So I always felt it was important when I was in big law and practicing as counsel to have both a sort of an external focus as well as an internal firm focus. So, when I was at the law firm or, whatever organization, I was also very much involved in some of the organizations that have been mentioned, arbitration groups, so that you can develop a network and you can develop your brand and you can increase your profile. So, by chairing committees. I chaired the arbitration committee of the New York City Bar. I was president of Arbitral Women. I chaired several committees for the AAA/International ICDR. I think through building a network and building a brand, as well as developing your skill set, that puts you in a position to ultimately be able to take the step to be independent. So I always encourage young associates to be outward looking as well as inward looking, and not, the day of just simply, being at your desk and working 15 plus hours a day and, just doing that for the next 30 years, those days are gone. Like now people, especially with the technology and everything, the world is global and people really need to network and collaborate with people around the world, not just in your law firm. So I did a lot of external professional development before I chose to go independent. I think a separate question, which we could have a whole episode on, is how do you navigate being an independent arbitrator, with none of the infrastructure that you had in big law. And if you spent decades in big law, it's a big change. I've navigated that carefully. So I spent about 6 months researching what was involved in being an independent arbitrator, and getting all the steps that you need, getting insurance, and there's so many logistics that have to be dealt with. And I was excited to join Arbitra. I wanted to mention that earlier, but I am also a member of Arbitra. And for a while, I had half of the screen background saying Arbitra, and that didn't work. So I had to lose that screen background. But I'm part of Arbitra, and they have provided invaluable advice in terms of how to navigate globally, exploring relationships and getting appointments. And I continue to be very active with organizations. I'm going to be chairing a new one in the fall for the ABA. And I think the more leadership positions you have, the more networking opportunities you have. Also, I think doing thought leadership work like your own, writing articles, speaking at events on substantive issues, showing the areas of expertise or knowledge that you have, I think is really helpful. So when someone's looking for someone, who's familiar with, the energy market or whatever market it is, if you've shown that you have that experience through either writing or speaking or being at committees where there's a project and these topics come up and you can share your knowledge, that's very helpful as well. I think I exceeded my time, so I stopped myself. Sorry for the pause.
No, it was really interesting. Thank you for sharing with us. Maybe Alex and Jay can also comment on that.
Alex, go ahead. You go first.
Thank you. Yes, I agree with Dana. Those are all things that are very important to do in terms of building your practice. I think something that is fundamental for international arbitration and having an international practice is the more you get out of your own, when you're in practice as counsel in a law firm, is to get out into the world. If you can go and work in another office in another country, do that. If you can move around, the more people you work with from different backgrounds and different countries, the more you are likely to get appointments in big international arbitration or just any international arbitration. That familiarity with different cultural spheres and legal systems is all very helpful. I think it builds your contacts as you do it. But yes, it's also important to have some kind of structure around you. You can do things on your own. I mean, if you're good with, say, IT or that kind of thing, which I'm not, but you've got to find that help from other sources if you don't have it immediately to hand. And speak to colleagues, speak to other people in the international who are also international in international arbitration, who are independent arbitrators. They've all been very helpful to me as I take this new step. That's been very helpful and very encouraging.
That is all really, really excellent advice. Certainly things that I have followed as well. I want to look at the question from a slightly different angle maybe, and that is when. When to make the move from a law firm to full-time international arbitrator. And I think it's very individual, but I think spending enough time in the law firm to have done a lot of work handling first chairing or international arbitrations in front of different arbitrators in as many opportunities as you can, and taking risks and chances and learning from all of that is critical. And then once you, I mean, for me, I got to the point where dealing with opposing counsel was like hearing nails on a chalkboard, and it was just so frustrating that, it wasn't fun for me anymore. And that's when I decided, I'm going to make the move from counsel to arbitrator, where people have to be nice to me and they have to laugh at my jokes. And so for me, it was really at the tail end of my career. It doesn't have to be, and it can be sooner. But the other thing I would say is you can be an arbitrator while you're still in a law firm. I'm one of the members of the US ICC's nominations commission that makes recommendations to the ICC for appointments. And one of the things we are always looking to find are young arbitrators who members of the nomination commission have come across and know of, either because they've seen them in a case or they've run across them in other environments. And we have confidence in their abilities, and we're trying to bring new people into the arbitrator community. And so you don't have to be independent for that. And frankly, I think if you go independent too soon, you won't have the depth of experience. You may have the confidence, but not the depth of experience to really be effective. And so I would encourage people to really get their knowledge base, their experience base behind them before making the move. And then making the move is awesome. I mean, when you get that first check with your name on it rather than your law firm's name on it, that feels so nice.
As a barrister, Jay, I can say that getting a check at all feels nice. Can I just ask one interject a question there? I'm not sure if Owen's approached you yet, Jay, from Arbitra to try and poach you, but at the moment you're working independently, and Alex and Dana obviously are in a what is effectively a kind of chambers for arbitrators, right? So in terms of that, they've talked about the sort of challenges of and I've heard many times, I think perhaps us at the bar being independent as a barrister and being in chambers and having all those things that Dana talked about insurance and GDPR or whatever else that we have to deal with, IT security, etc. We've always had to do that ourselves anyway. How are you finding that side of things? And then I'll come back to Dana maybe and see how much has an institution like Arbitra, and there's a few of them around now. There are other institutions around available. How's that affected your ability to get on with the business of arbitrating? So Jay first.
Yeah, I really miss my firm's IT department. I actually love it. I mean, I started out in a small trial boutique, and I went to a big firm. And, because for me, this is, I am retired, so this is not sort of, I don't need to be a full-time arbitrator, and I don't want to be a full-time arbitrator. I want to be an arbitrator who takes cases that are interesting and has time to be available for the parties and there's time to really dig into the cases and be knowledgeable and I feel like I can do that effectively independently, like a barrister, where I do have an IT consultant who I've hired to help me with IT issues, and I do have insurance, and I've my wife and daughter help me do my website, and so I'm able to do those things with resources that I either go out and find or I learn on my own, and that itself is fun. It's fun figuring out how to set up an LLC, and fun figuring out how to set up, and yeah, it's all part of life experience, which I think ultimately makes you a more effective arbitrator and a more interesting person.
Thanks, Jay. And Dana,
But
what have you found?
that's me.
Sorry. Go ahead, Jay. Go ahead.
No, that's it.
Dana, what have you found most helpful about being in a structure?
Well, when I first started as an independent arbitrator full time, I was on my own, like Jay, and I had researched sort of what are the things you need to do, what are the resources you need to have available. So I have an IT consultant as well. I got help with a website. I did a lot of the startup on my own, and then I joined Arbitra a year after I had gone independent. So Arbitra has been really valuable to me in terms of developing my strategy and growing my practice as an international arbitrator on a global platform. Less for the mechanics of like a website, or although they help with anything, I haven't asked them for everything, but I think, if I put a question to them, they would assist me. They have made introductions. They have helped me, especially some aspects of insurance that I thought I had some insurance. I realized I needed more insurance, and they helped me with that. They helped me decide strategic decisions with respect to cases to take, with respect to speaking engagements, with respect to business travel, BD opportunities. It's been very nice to have the team at Arbitra who I can collaborate with and develop a strategy going forward. And I do want to do this full time. I'm not retired. I'm nowhere near retired. So working with an organization like Arbitra for me is really important.
Great. Well, it sounds, Jay, that if you take up a position in a structure, you may be doing your wife and daughter out of a job there. I'll hand back to Flavia.
Sorry, I was on mute. Well, I think we always started already touching into the next question we wanted to go, but basically the next follow-up question would be how to transition from a more local experience to a global experience. And I think Dan already touched on it, Alex also, but how to foster appointments in other jurisdictions. Is it only like knowing the language or having experience in that legal environment or that culture? Or how do you address that? Is there like specific jurisdictions that you focus on getting more appointment? For example, if you're in New York, maybe getting more appointments in London might be easier than in Brazil. Or maybe if you know Portuguese, should you focus in Brazil, Portugal, or should you try to go to jurisdictions where there is like a more opportunity for arbitration? How do you decide strategically, as Dana mentioned, which conference should I actually invest in going and taking that expenses, which we all know it's not, especially once you are independent, it's not like trivial expenses. So maybe you can continue to share what you're already sharing and get a little bit more deep on that.
Did you ask me? Yes?
You can go ahead, Dana.
Okay.
Thank you.
So, when I was president of Arbitral Women, I was everywhere globally, and I got to meet so many people. So that was really helpful in terms of getting a sense of the international arbitration landscape and the people around the world. After 4 years of being president of Arbitral Women and I stepped down, the pandemic was also ending. So a lot of my international travel, so to speak, was virtual. Some of it was in person, and the last pre-pandemic in-person arbitration week I went to was Hong Kong Arbitration Week in the end of 2019. I also did New York Arbitration Week, of course, because I'm here, and some things in the States. But now that the world has reopened, you do have to make strategic choices on where to go, and I think language is one of the considerations. I did spend some time with a UK-based international law firm, so I feel that my contacts with London are long lasting, and it's an important market to me. But that international law firms have a footprint, at least the one I was at, in many, many countries. So it can turn more on the subject matter of the case or your availability for the case as much as deciding where geographically to focus. That's been my experience, at least.
Thank you. What about you, Jay? I think Alex already spoke a little bit about that.
Yeah. So I spent over a decade in international arbitration in the U.S. and then over a decade in London, and had cases all around the world. And I think what's most important is to maintain connections with the people you've come across. If you do a case involving a Korean party and you have a Korean co-counsel, staying in connection with that person, because you just never know when you're going to be the right fit for a case where they have the opportunity to make an appointment. And so the more you can build your network, as Dana said, she through Arbitral Women was able to create huge connections. And then, and remembering that every time you have a touch, a connection to a person, you never know when that's going to come back and turn out to be an appointment or somebody asking you to be counsel in a case. And so being your best self, wherever you are, whenever you're dealing with people, and showing them that you're a decent, honest, intelligent person, because I'm sure everyone on this call is. And that's the way. You just never know when. Some of the cases that I got hired to handle as counsel came from somebody I met 15 or 20 years earlier at a conference who I had no idea I had any impact on. And I think it's really always remembering it's not a performance, but you're on stage all the time.
Thank you. I do agree, things come up not 5 days after. You have to be patient and do your best always, because you never know. Maybe within 10 or 15 years, you'll be back. Alex and I, we worked together at the Freshfields, 15 years ago, maybe anytime soon we will meet again in an arbitral tribunal or in a different perspective. Alex, maybe you can share a little bit about your experience having moved around and speaking different languages as well, how that helped you.
Yes, I think it does help either to focus on an area of expertise that you've worked on in your time as counsel, because that can be a very rich area where you develop contacts, and that counsel who are appointing will understand that your way around that type of case. But languages is very helpful as well, because I think if people are looking for somebody who speaks a language but is not a national of a particular country, that can be a reason why suddenly the fact that you speak someone else's language, even if you're not qualified in that jurisdiction, there's a much smaller number or pool of arbitrators who are going to be able to do the case if it's in that language. Even bilingual arbitrations where you need to speak both English and and another language, say Spanish or something, are very helpful if obviously you're fluent enough in the language to be able to at least read documents in that language for a bilingual arbitration anyway, and hear the witnesses and understand what they're saying without a translation. So those are definitely very helpful attributes to have. If you don't have those attributes, then others that are helpful are particular specialist areas as well. Those can be very useful if you develop your contacts through cases and through going to conferences in particular areas. You can build a reputation that way.
Thank you, Alex. I think I will move back to Federico for probably our last question.
Okay, thanks, Flavia. Okay, so we've saved the best to last, right? This event is brought to you by NYLON Arbitration. And whatever you think of our title, it represents New York and London, and not some type of textile, don't worry.
Mm-hmm.
So really I wanted to drill down. You guys all have a connection with New York and or London. And they're two, as Michael said, you know, they're two great superpowers of international arbitration. They are big seats for international arbitrations. They have a long history. They have a great supportive court system. But I wanted to really touch upon the differences. So, you know, you've acted, whether as counsel or as arbitrator, in both jurisdictions, both in terms of what you've talked about, which is the business side of getting appointments, getting known in institutions, but also potential cultural differences. You know, I'm always forever here having discussions with Kabir and Michael about how London is much better than New York, and all I get is how the food is rubbish in London, which I have to say is very old hat. And London is one of the epicenters of Michelin quality cuisine these days. But let's start with you, Alex. You in your intro, you mentioned lots of things, but you did mention you're actually an Englishman living in the US. So how's that? Let's get your thoughts.
Well, yes, I'm now after 16 years in the US. I'm now a US citizen as well. So I straddle. I can wear both hats. I think that the differences between English law firms and US law firms, my experience of that was smoothed, if you like, by the fact that I was working in an international firm that has very when it's in the US, it's a US firm with lots of US colleagues and partners. In London, obviously, it's an English law firm. In Germany, it's a German law firm. So that smoothed the experience, if you like, didn't make it a completely, jumping from hot to cold water or whatever for me. It was very helpful to work with US colleagues and to be able to consult them about US law aspects of cases when they came up. And now, after so many years, I sometimes I don't notice, is when I come back to London, that people go, oh, that's a US expression, or that's a US way of doing things. Or when you start to work on, I remember on my way back to the first arbitrations I worked on, where it was just English lawyers on either side. Everyone hired a barrister, you'll be glad to hear, Fred, so that it was almost like English litigation. And everything just came from English litigation. That in the US, it hasn't been that way, except for small arbitrations where I've worked on, where both counsel on either side are US lawyers, where the same kind of single country focus appears again. It's been very different, because I think the teams I've worked with in the law firms are from every variety of country you can imagine, particularly Latin American in my particular case. So it was never a single experience. It was never entirely a US experience or entirely a London experience. From the time that I moved to Freshfields, I think it was more monocultural in the other firms I worked in before that in London, or at least a little more so.
Thanks, Alex. Jay, turning to you, you spent, as you said, 10 years practicing in the US, 10 years in London, so you've got a good grasp on both sides of the pond, as it were. What about in terms of beyond, kind of putting on an alternative litigation, sitting as an arbitrator in the tribunal hearing room, do you notice differences in, either indoctrination or lags, despite efforts to harmonize, and despite, as Michael said, we're two countries separated by a common language, despite that kind of input, that context, do you see more similarities, or do you think the differences become highlighted? And if so, what are those differences?
I think the answer to that question isn't country specific, it's arbitrator specific. And so if you get an arbitrator who is schooled in internationalism, true international arbitration, whether they're in the UK or from the US, it's pretty similar. I'll put barristers aside for a second because they're their own unique animal.
We're sui generis, right?
You are. But I think, and this is actually true for really international arbitration barristers like you, Federico, as well. There's sort of a common language.
Payments, checks in the post.
Excellent. There really is sort of a community and a common way of thinking, and this notion that Americans are more mean-spirited or aggressive or partial than Englishmen. I don't think it's true. So in that respect, I think it's more the tribunal members than where they're from. I will say what I think England has over the United States is the arbitration community is concentrated in one place, London. And as a consequence, it's more of a community. People just come across each other much more frequently and much more easily, because it's not so expensive. You don't have to fly halfway across the country to go to a Miami conference or a New York conference or a San Francisco conference. And that creates bonds, I think, in the community in London that you don't see in the United States, at least not as strongly. I mean, you'll see it within New York or within Miami, but you won't see it across those cities nearly as much. And that's an advantage for London, because it allows a lot more cross-fertilization and a lot more. If you're dealing with people on a day-to-day basis or on a routine basis, and you never know when you're going to come across them again, you're more polite and decent. Whereas in America, where you're much more disparate, you may not come across one another again in 6 months or 6 years or 6 decades. People feel less of that sort of social cohesion.
So that's analogous to me as sort of social media trolling, Jay. You're more, if you're not going to see the person, you're going to have any contact, you're more likely to not be as nice or have the same courtesy.
And that I think you can see in U.S. litigation versus English litigation. In U.S. litigation, you get people acting in really awful ways towards one another because they're from completely different places and they will never see each other again. In England, you don't get that. I mean, everybody is my, Pollock, for example, was a difficult man, but everybody is, my friend so and so, and there is a level of deference and respect, even though people still fight really hard.
Great. Well, look, Kabir, Mike, if you're listening, you just heard Jay say that London is better. So in your faces.
Can I defend New York before,
Dana,
before we forget it?
Before you do, you also can get Guinness on tap in London much more easily than in the United States.
Of course you can, and it tastes better as well.
I won't dispute that.
Dana, your rebuttal now and in favor of New York.
So I think that New York has really blossomed in the past 10 plus years. It's been a center of arbitration for a very long time, but I think the arbitration community has made a much more concerted effort to be a community, and in a number of ways. For example, the establishment of NYIAC, the New York International Arbitration Center, which is a hub for thought leadership in the area of arbitration, as well as hosting hearings that are seated in New York. So I'm now part of NYIAC. I'm on the board of NYIAC, and I see how much energy is put into building and maintaining the international arbitration community in New York. Also, we've had New York Arbitration Week now for I don't know how many years. I was on the committee when it first started. I've rotated off, but I know that it is still alive and well, and we look forward to it in November. There are a number of other organizations in New York. There's the International Arbitration Club of New York that brings the arbitration practitioners together. So I think that New York does have a pretty close-knit arbitration community, as does London. I'm not suggesting otherwise, but I think that there's actually a much closer community in New York amongst the arbitration practitioners and arbitrators than one might think, if from a more distanced view. In terms of like, what are the differences between arbitrating in New York and arbitrating in London? I think there are a lot of similarities for the reasons that have been stated, that, essentially it's a global practice. It's an international arbitration practice, and a lot of the procedural aspects have been sort of harmonized, and that there's been a lot of energy put into that by the IBA and other organizations and the arbitral institutions. So some of the things that I really learned, well, when I joined Allen & Overy, the first thing that was emphasized was we do all our own advocacy. And I didn't know what that meant, because New Yorkers always do their own advocacy. Like so then it was explained to me that there are these, different groups of people who do different things in terms of advocacy. But at Allen & Overy, that was a theme, and we did our own advocacy at Allen & Overy and every firm I've been at. But one thing that I have to compliment the arbitration practice in London for, which may or may not be well received by people, but the skeleton, I'd never heard of that until I was doing arbitrations in London. And the skeleton, I think, is a very interesting way of skeletons, a very short, like 15-page summary of the key aspects of your case right before the hearing starts. And there's nothing like that in U.S. practice typically, not court practice nor arbitration practice, but the skeleton seemed to be sort of a mainstay of arbitration in London, at least the ones that I was doing in London over a period of 10 years. I spent more time in London than home. And so I think there are some gems in the practice in some of these major arbitration hubs that could be, brought into, I know there's a concern about the Americanization of arbitration. I think that concern's a little bit overinflated. I don't think that the arbitration bar in the US and in New York is really practicing in the way that some of the court litigators, some of the sharp court litigation practices that you see in some parts of the country other than New York and maybe in New York, you don't see that so much in international arbitration or domestic arbitration in New York. So I think that the community is tighter than maybe is perceived from abroad in New York. I think there are definitely some important attributes and gems of practice outside of New York and outside of the US that would be welcomed in arbitrations around the world, including New York. And I had a case, not only was I doing arbitrations seated in London, but I was then enforcing arbitration awards that were rendered in London in US courts. And so I was definitely combining my New York law, my New York experience together with my arbitrating in London. And I had one case where actually we had an enforcement proceeding in which we both sought to enforce the arbitration award under the New York Convention as implemented by the Federal Arbitration Act in the US. And also in the alternative, enforce the UK judgment that had confirmed that same award. So we presented to a US judge who was not steeped in international arbitration these two alternatives, enforce the award under the New York Convention and or recognize this UK judgment. But the tricky part about the award enforcement was that there was a time lag because there was the statute of limitations period was shorter than when we got to court. And so we had to explain to the court why we were coming to the court later. And we ultimately were able to explain to the court why the statute of limitations or the limitations period to enforce a foreign award in the US should be told. And that was a very interesting case because there was very little, if any, law on that in the US. And ultimately, the statute of limitations was told. And so the court ultimately confirmed the award under the New York Convention and the implementing statute, Federal Arbitration Act in New York, and did not engage in the alternative confirmation of the UK judgment. But it was interesting to sort of bring all that together in one case in a US court after a long, hard-fought arbitration. So we are very connected.
Good, good. I just wanted to touch upon something, a slightly different angle on that of sort of London and New York, which is the sort of the practicalities of, say, doing a hearing. And that includes not the legal side or the arbitrator profession side, but the real sort of practicalities of flying in, the hotel's availability, etc., the facilities, the being able to have a meal in a restaurant and talk about deliberate afterwards, and all of those kind of things. In terms of New York and London, or even the ability to know, now that we have hybrid hearings or whatever, the ability to bring everyone in, and whether it be because of time differences or whatever. How do you guys feel about that? Let's turn first to Alex on that.
Well, I have a story about a hearing in New York where I suddenly got called up months after a hearing by American Express to ask why I hadn't paid $28,000 that was owing. And I never used this corporate card that apparently had just been, it worked out later, it had been given as a guarantee for the hotels in a hearing that was supposed to be paid by the firm or something like that. And anyway, they'd just taken it off my card, and then I was chased by American Express. It gave me a very hairy moment because I thought, my God, my identity's been stolen or the card's been stolen. Yeah, they are, I think both London and New York are expensive cities for hearings, in the sense that they're just expensive cities, and if you have to bring teams in, that can be difficult. It's obviously harder for you if you've not got an office in New York or London, depending on who you are. But all of those things can be overcome, and I think the quality of the hearing centres that you've now got in both places, whether in London with the new facilities that you've got there, or in New York with NYIAC and everything, that's made life a lot better. There was a time when you were looking for hotels to have the hearings in, and I personally don't particularly like having hearings in hotels because they're just inconvenient. So I think that is all a lot better on the logistical level. The alternative of going somewhere else that's cheaper, I don't think really works, because I think all of the facilities, the flights, and everything like that make a big difference. Having if you're in a big city, and just does increase the cost. But if a hearing is only a week, then perhaps at most you're going to be spending maybe 2 weeks if you're flying in from somewhere else with a week of preparation. Not cheap, but better than a trial that may last for months. That's for sure.
Great. Okay. Thanks. That's incredibly helpful. Jay, anything to add on that?
Yeah, a couple of things. I think if you have a hybrid hearing, depending on where the parties are, but in the abstract, London is a better place than New York, because for time zone purposes, if you have people in Asia and people in the Americas, London actually makes it possible. If you're trying to do it from a US time zone, the folks in Asia are just really hurt. And so that's sort of from a practical perspective, depending on who the parties are and where the witnesses are from. In terms of the resources or the facilities, New York has caught up. I mean, I can remember 15 years ago, you had no choice really but to do it in a hotel ballroom if you were in New York. London, you had the old IDRC Center, which I found charming. Most people found decrepit. It
was charming in an English way, Jay.
Exactly. There you go. No air conditioning. At least it went out on us during the summer. And poor Lord Mustel was sitting there melting in his chair. But now there are good facilities. The IDRC facilities now are quite impressive. Frederick, you and I did a case there not so long ago. And there's another hearing center which I've not done a case in, but I had the opportunity to visit, which is, the Taj Mahal of hearing centers, I gather. It's very impressive. So I think there are, and in New York, as Dana has already said, there are now facilities. So the facilities are good. Restaurants, great restaurants, both places. Pubs are better.
I'm
in
glad
London.
to hear you say that, Jay.
Yeah. And court reporters, all that stuff. Both jurisdictions have wonderful facilities.
Great. And Flavia, you'll remember that we had an Asia America case, and unfortunately, poor Flavia was waking up at 4 a.m. or 5 a.m. to start the hearing. But I was sitting pretty, getting up at 10 and finishing off at about 4 p.m. So I still got to see my kids throughout that week.
You always sit pretty, Federico.
Well,
Thank you very much, Jay. Dana.
I was just chairing an arbitration that was seated in New York, and it was hybrid to some extent. And so the European witnesses who were testifying via, remote hybrid, that we heard them in the morning, U.S. time. We were very accommodating of people's respective time zones. We also did this hearing starting the Tuesday after Memorial Day weekend. And I tried to impress upon counsel that Memorial Day weekend in the US is it's the kickoff of summer. A lot of people take vacation. It's graduation season. It's wedding season. It's everything. Do you really want to have a hearing starting on Tuesday after Memorial Day weekend? And they were dead set on doing it. And we did it at the AAA, and amazingly, it went so smoothly. Many of the people who were normally at the AAA were away because this was the high holiday, kickoff season or attending graduations. But they had ample staff who were equally talented, and it all worked out really well. And we had fine dining in New York. That was not a concern. But we were concerned about the tribunal dinner the night before the hearing started, because that was literally Memorial Day and a lot of restaurants were closed. So there was an effort made to make sure that where we met for dinner was open, and indeed it was. So I think that using hybrid for the hearings, I think is absolutely beneficial. I mean, so much time and cost are saved, both from the witnesses, but also the clients can participate to some extent remotely if they choose. I mean, it's just, since we've come out of the virtual, sort of all virtual period during pandemic to this, future, I think to stay hybrid mode, it really improves the efficiency of arbitration. And I think that everybody's learned to navigate technology and do it. It's kind of tricky sometimes when you're doing that with translation, with the court reporter being in New York and the witness being somewhere else, and the translator being in New York, but the Czech translator, the second translator who would agree or disagree with the translations in a different place. There are little logistics like that you just have to make sure when you're chairing the arbitration, you make sure that nobody's sort of speaking over each other and that there's time for people to process those aspects. But overall, I think, whether it's New York or London or, many places in the world now, you can do it very, quicker. It's actually, I find it quicker. I didn't get to see my kids much that week. I'll be honest with you. I don't know about this 10 to 4 thing. I've never seen it, not in private practice and not as an arbitrator, but it was definitely a much more efficient hearing. It would have been probably 2 weeks, and it was only a week, given the hybrid aspect.
Well, when you switch New York for London, Dana, and start sitting here more often, you may get to see your kids more often. That's all I'm listen, guys.
Frederick, I've got to jump in if there's 2 minutes with a holiday
please.
hearing story, because it's hilarious, I think. So that same hearing I was in the IDRC where Lord Mustill was melting because of the lack of air conditioning. The hearing was the last week of June, the first week of July. And on July, I guess it was 2nd or 1st, because the 1st was a Friday. The 4th was a Monday. And I'm obviously American, and Gary Bourne was on the tribunal, and he's American. And Lord Mustill says on Friday afternoon, Mr. Alexander, I just want to let you know we will be sitting on July 4th. Now, I know it's your holiday over there in the United States, but we have it as a holiday here in the UK as well. We call it Thanksgiving Day.
See, the English can be funny, Jay. Well, look, I just wanted to say, send apologies on behalf of Flavia. In true arbitration practice form, she's gone off to a hearing, which starts in about 10 minutes. So I think we can all forgive her for that. But we're coming close to the end of our time. I have to say, it's been really, really great fun and highly educational for me. I'm going to ask the arbitration channel whether there are any questions, and if so, they can chuck it over to us on the chat. But whilst we wait for that, I just wanted to ask you guys, is there anything else you wanted to add, or is there anything you wanted to ask each other?